in estimating loss or damage arising from breach of contract. So what we need under section 73, there must be some loss or damage, and that loss or damage has to be estimated. While estimating, the court has to take into account one factor, and that factor is that the party which suffered the loss must have taken all those possible measures which will reduce the quantum of loss or damage. In other words, as the language of the explanation says, in estimating loss or damage arising from breach of contract, means which existed of remedying the inconvenience caused by the non-performance of the contract must be taken into account. So because of non-performance, certain loss will be incurred by the other party, but it is the duty of the other party also to minimize the losses if there are means which can mitigate the losses. The other party cannot simply say that let there be any amount of loss because I am entitled to receive compensation, so why should I bother? That approach should not be there. The party which suffers the loss has to make all possible efforts to minimize the loss. It is his duty. And the court will take into consideration that if he could have minimized the loss and yet he deliberately did not take those measures, then he will get lesser compensation.